You are listening to High Frequency Radio. I'm your host, Yusef L. It is Monday, March 9th, 2015, broadcasting live from sunny Southern California. And when I say sunny, I do mean sunny. I just got through going, just gallivanting around the United States, and ain't nothing like the sun in California, boy, I'm telling you. Peace to everybody in the chat room. What up, what up, what up? Give a shout out to everybody. 63250, creating your business. About to high growing his food. G still learning. We got Sovereignty God, Farley Walker, Private International Trust, Grantor 77, Sedan Rules, Omnipresence Media, North Shore, Massachusetts. What up? Mojo 504, and all the other guests in the chat room. Hey, all my people on the phone lines, all the truckers out there. Keeping commerce going. What up, what up, what up? Honk your horn for me. I had a little issue this morning, y'all. That's why I'm a little late getting on the air. Little issues. But we're going to have a good show today. We got a good show lined up for you today. I got some things I want to talk about. We're going to talk about this discharging debt. We're going to talk about criminal cases. We're going to talk about making purchases with UCCs and all that this morning. I'm going in. Okay, I've been getting a lot of questions about stuff. I've been getting hit with a lot of it seems like it's kind of like the what's coming off of the webinars. I did a webinar on negotiable instruments. All of y'all went out there and experimented, went try to buy cars and houses and all this kind of stuff. Then I got some people hitting me up on these criminal cases and everything. So I'm going to take it back today. I'm going to take it back. We're going to get into all of these discussions this morning. We're going to talk about what to say in court, administrative processes, set off, offsets, and in particular, just what are the rules of the game? What are the rules of the game? Now, if this is your first time listening to my show, you should know that this is kind of like a different type of show. We talk about other things. We talk about the things other people don't want to talk about. I was listening to another blog talk the other day, and it just amazes me how much people just do not understand what is going on in this country. As far as what was it? I was listening to a show. They were talking about marijuana and states' rights versus the federal government, how the federal government, how the judges were just ruling against people and nobody understands what's going on and how corrupt the judges are. I'm going to just call it like it is. The United States is primarily composed of a citizenry that are functionally illiterate. That might, make some people mad, but it's just what it is. Like the other day, me and Q, we were out of town. And I had some people, and we were watching. We were reviewing. What were we looking at? What were we reading? We was reading Super International Law. That's what we were reading. We were reading Super International Law and reading some information on the driver's license. And I was just I was just kind of pointing out how much stuff you can find out if you would just read. I know it's amazing. How much stuff can you find out if you just read? So that's what we're going to do today. We're going to read some stuff today. And I'm going to do some question and answer. All right, so I'm going to delve right into the subject matter. Let me get right in this. Let me send out a little thing real quick. We're going to get right into it. First thing I'm going to talk about is buying stuff with the UCC because you got a lot of people. They're trying to buy cars, they're trying to buy homes. You know, they put together an international bill of exchange, things like that. Let me first of all let me put my disclaimer in. The UCC is not for purchases. It is for setting off debt or offsetting debt. It's not for purchases. You are setting off debt because there is no money to pay for anything. So you should never even be using that word purchase because you can't make a purchase because you can't buy anything because there's no money to buy anything with. All you're doing is just moving debt around. Look in your wallet. You will see you have a Federal Reserve note. That Federal Reserve note represents what? Debt. So when you go buy something, quote unquote, all you are doing is exchanging debt paper, moving around debt. That's it. Once you get these concepts firmly etched in your mind indelibly, then you can begin to address, setting off debt, doing things like that. But right now, a lot of y'all ain't got the concepts firmly etched in your mind. You just kind of just want to buy some shit, okay? Let's talk about that for a little bit, especially for the new people. Let me go through the rules real quick. Rule number 1, there is no money. What do we mean when we say there is no money? Well, it's on the public record that the United States of America is bankrupt. This is on record in House Joint Resolution 192, June 5th, 1933, Public Law 73-10, and all associated policies, and it's been codified in Title 31, 5118D2, which is the rescission of the gold clause, which is enumerated in Article 1, Section 8, Clause 10, I believe. Rule number 2, there is a public and a private, and they do not mix. They don't ever mix them. Don't you ever mix them. Public and private does not mix. Let me reemphasize that. They don't ever mix them. Don't you ever mix them. Rule number 3, stay in honor at all costs. You have to be honorable in all of your dealings. You cannot be trying to do things for hidden agendas, surreptitious acts, act dishonorably, think you're going to go out and kill somebody and get away, think you're going to go and do 90 miles an hour through a school zone, and, no, those are not honorable. You have to be honorable in all your activities. Think you're going to ignore some written correspondence that gets sent to you when you didn't sign a contract on something. You have to be honorable. And rule number 4, do not participate in public plays or public controversy. Why do we call it a public play? Because, I'm going to tell you why it's a public play. Because they are keeping secrets from you, and they don't want you to know, and they don't want you coming into the courtroom alerting the public. So they're going to put on a stage play for you. It's going to appear to be real, but it's not. How can something be real when it's being put on by fictions? It's fictions. They're legal fictions. And those are the 4 rules. You would be wise to write those down. Next, you need to know the hierarchy of the law. You have natural law. Everything descends from God's law. God, that is the real law. All that other shit is some bullshit, okay? Positive law is drafted for people who do not honor God's law. So from natural law, you get positive law. From positive law, you get substantive and procedural law. From procedural law, you get remedial law. And from substantive law, you get public and private law. Public law is constitutional law, criminal law, administrative law, public international law, tax law. And then on the private side, you got contract law, status law, property law, tort law, family law. Know your hierarchy of the law. Get the fundamentals down. You can't go to the NBA if you can't go to the left. If you can't make a left-handed layup. So let's get your fundamentals down first. So now we got that out the way. Let's talk about these purchases. You know, people going out trying to acquire automobiles and things of that nature. All right. If you would have taken my secure party class, anytime that you give a negotiable instrument, you always include processing instructions with it. How are you going to give somebody this weird-looking document and they don't know how to process it? Huh? They just supposed to automatically know? You're the private man. You're supposed to tell. They public entities. They don't know how to process no private paperwork. Well, they may, but they want to know if you know how to do it. So you always include processing instructions with all of your stuff, man. Let's see if I got some processing instructions in here for you. I'm going to read these processing instructions over the air. So you can't say I ain't never, did nothing for you. I kind of want to bust out into rap, Who the fuck is this? Paging me at 5:46 in the morning, crack of dawn, and now I'm yawning. Wipe the cold from my eye. See who's this paging me and why. It's my nigga Pop from the barbershop. Said he's in the gambling spot and heard the I don't want to do that. I go off on y'all now. Let me pull this up. When Biggie Smalls dropped that, boy, that was dope. He dropped that right there. When it came out, that was one of them albums, when it first come out, I remember when the cat gave me the tape. He gave me the tape, said, listen to this. He was a New York cat. I listened to it. I turned on the first song, listened to the whole album my first time out. That's what these new rappers can't do. They can't make y'all do something like that. You just you turn on, you just start with song number one. You don't turn off until they reach the end. Then you want to, listen to the whole thing again. That was Biggie Smalls. Anyway, let me get to this, this letter of advice. All right, what I got here? Okay, I got this. This is some processing instructions that go with your negotiable instrument that you're gonna put out. All right. Now it's gonna to be included as an allonge. What is an allonge? Write that word down. Allonge. Write that word down. It's called an allonge. 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 Matter of fact, you have an allonge to a note. Okay? An allonge is a slip of paper affixed to a negotiable instrument as a bill of exchange for the purpose of receiving additional endorsements for which there may not be sufficient space on the bill itself. Now, when you get this, let me pull this up. You're going to see this is where you're going to have your instructions attached to that. And let me read this to you. Now, you're promptly going to mail this to Jacob Blue by certified or registered mail. And you're going to have a restricted endorsement. When you send something privately, there is a spot on the green card that says restricted endorsement. That means that the only person that can get that correspondence is the person whose name is on it. Doesn't that keep it private? Doesn't that keep it private? Promptly mail via certified or registered mail receipt, the signed instrument with these documents to Jacob Blue or his successor, the Secretary of the Treasury, Department of the Treasury, 1500 Pennsylvania Avenue, Washington, D.C., 2220. You're going to put your name as a private party, your address on here. And it's in regard, it's a notice processing of a bill of exchange, which is a time draft. And it reads, I'm in receipt of the attached offer requesting payment. Please find the attached bill of exchange, the processing of which will discharge the entire current amount stated on the claim herein accepted for value. This attached negotiable instrument is presented under the authority of House Joint Resolution 192, June 5, 1933, Public Law 73-10, and UCC 3104C. Spencer versus Sterling Bank, Guarantee Trust Company versus New York, blah, 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 and the Wiccan Negotiable Instrument Volume 3, including 2002 supplemental, on the undersigned UCC Contract Trust Account. Notice it's called a UCC Contract Trust Account. You're setting up a trust with the government. That's what your secured party paperwork really is. It's a trust. It is an indenture, and you're making the Secretary of Treasury a trustee by the Power of Appointment Act. Read it. Privately, you're doing this. And the incentive for him being a trustee is you're giving him a $200 million bond, and the interest on that bond is to be utilized by the federal government. The principal is to be utilized by you for living your life, taking care of public debt. The following steps are required by regulation to settle this account. This is not a Treasury security, nor involving a Treasury Direct Bond account, nor is this instrument to be processed through the Bureau of Public Debt, nor is this instrument to be applied toward the national debt. These are certified funds. Number one, I probably would take the national debt off, though. You let them do whatever they want to do with it. You can take that part off. The attached negotiable instrument, in accordance with UCC 3104, and complies with the terms of the original contract. The following process must be followed to the letter in order to satisfy the claimed amount due on this account and discharge of this debt. My personal UCC contract trust account has been established with the Department of Treasury and may only be accessed with my approval through the bank account of the claimant directly to the Secretary of the Treasury, drawee. The original negotiable instrument is certified and must be presented by claimant's financial institution through the Treasury Tax and Loan Department via certified or registered mail, return receipt directly to Jacob Lew, the Secretary of Treasury, or a successor, Department of the Treasury, 1500 Pennsylvania Avenue Northwest, Washington, D.C., 20220. The item processor at claimant's financial institution with full identification and Bailey, authorized Treasury Trust and Loan account, signature is to present the original negotiable instrument along with instructions, notice, and stamp claim to the Secretary of the Treasury, Department of the Treasury at the above address. Now, let me say this. The Secretary of the Treasury is the point man for offsetting or setting off all your debt. The Treasury Department always has to be apprised whenever there is any creation of any money or any debt is being settled. They hold the ultimate books for the entire nation. And at the end of the day, all the books have to be settled. So let's use some common sense, as my teacher used to tell us in high school. Common sense is that sense by which no other sense makes any sense at all. So we're going to use some common sense here. The Treasury Department is the bank. All these other banks that you see everywhere are just intermediaries. That's why they give you service charges. They're providing a service for you. The bank for the nation is the Treasury Department. They are the receivers for the bankruptcy of the country. All of the property in this country has been placed in trust because they are bankrupt. That's what you do when you go into bankruptcy court. You have a bankruptcy trustee. When you file bankruptcy, whether it's Chapter 11 or Chapter 7, they put all your property in trust. That's why nobody can touch it. But if you liquidate it, like with a Chapter 7, all right, they're going to sell all your property for your debts. If you do an 11, they do a reorganization. That's what the country is going through, a reorganization for the payment of debts. And through a process called a novation, write that down, Novation, they have made you responsible for the debt. It's called a novation. I don't have no time to read no definitions today. You're going to have to look them up yourself because I got to roll through this. Now, What we're attempting to do is what is called an accord and satisfaction by use of an instrument. This is UCC 3-311. If you don't have a copy of the letter, I'm going to send it out in an email blast. You will need to be on my email list. You need to go to radiohighfrequency.com, put in your email information directly immediately after this show. I'm going to email this letter out on the email blast. That's how you're going to get it if you want it. Let's keep going. 5. Claimant's financial institution is to put a hold on claimant's deposit, retain the document copies, and await the return receipt card from the federal window, noting the date the original negotiable instrument was received at the federal window in accordance with public and banking policy. For out-of-state transactions, the UCC and banking regulations stipulate 15 days. Now, they have 15 days to do all this. They usually try to do it in 10. And let me say this. You got to understand, first of all, that no money is going through the system. When they say they're going to wire some money, ain't no damn money going through a damn wire. I hope y'all understand that. What is happening is they're sending an authorization, and all they do is lodge it in their books. This is all accounting. This is all accounting. What they do is they put it on their books, and then they get permission from the Treasury Department to add it to their deposit. But the Treasury Department needs to notate that. Why? Because there's taxes that have to be paid on it. So understand that there's no money flying around in electricity around the country. All that is happening is debits and credits that are being ledgered in a book. And the ultimate holder of the book for the entire nation is the Secretary of Treasury. And they have to keep their books balanced. That's why they got the IRS, which is their debt collectors, going to come out and get your ass if you don't file your taxes and report your income and do all this kind of stuff. Because they got to keep an accounting of everything. Let's keep going. The copy of the negotiable instrument is to be held at the financial institution until the required period for the federal window, Regulations J and Federal Reserve Regulations Z, Truth and Lending, 12 U.S.C. 226.1 et sec. The order property has passed. On the 16th day, the full face amount of the negotiable instrument is to be released by the local financial institution's TTL department and credit the claimant's account for discharge of the claim. Now, after 16 days, if they don't hear anything, this is how privacy is maintained. What is the principle behind silence? Silence is what? Acquiescence. So if they don't hear anything in 16 days, the bank is supposed to ledger the account. You are supposed to notify the Treasury Department by what is called an authorization of credit. Some people call it a letter of credit. It's an authorization for the use of credit. And what it does is you got to think about this. Think about this now. You filed a bond with the Treasury Department. Through tacit procreation, the Treasury Department has agreed to be the custodian of your documents and honor your instructions sent in your package to the Treasury Department. Now, you go out and write a check against that bond in the form of an international bill of exchange, and they're going to send it to the Treasury Department. If the Treasury Department has no prior notice from you that this is what you're doing. This is why whenever you do a negotiable instrument, you simultaneously send an authorization for the utilization of credit, restricted endorsement, to Jacob Lew in his private capacity, letting him know that this is what you're doing. Now, when he receives a teletype from the Treasury Tax and Loan Department of the financial institution, he's prepared. He already knows. A gentleman always gives notice. To ensure that claimant's financial institution receives full credit to their TTL account, claimant's financial institution is to take the retained copies of this letter of advice, the copy of the original claim accepted for value, and the copy of the original bill of exchange, and enclose these documents with the institution's next remittance of estimated taxes to the Internal Revenue Service. Notice it said estimated taxes to the Internal Revenue Service. Before enclosing these documents with the remittance, the institution's bailee, authorized TTL agent, must endorse the copy of the original bill of exchange on the top reverse side of the instrument. Now, on the bottom of that instrument, you can put a stamp and sign through it. That lets everybody know that you have the final word on a negotiable instrument. Do y'all understand that? And for people out there who don't know about putting stamps on negotiable instruments, there is a book that you can read, because a lot of y'all, y'all was back there doing the thing with the, y'all know what y'all was doing. Y'all was trying to pay y'all bills by using the voucher, putting 4 stamps all in the corner and all that shit, and sending it to the Criminal Investigation Division down there in Utah, I think Kentucky and all that, and in Washington, D.C., the IRS UCC Division in Washington, D.C., to set off y'all debt. Y'all putting like $1 stamps on there, and not knowing why you was doing it. Because I'm not the kind of person that just follows the crowd. They got a book you can read on that. The significance of stamps used on banknotes. What they call revenue stamps is what they're called. That's the technical term. But I'm going to go ahead and put a link in the chat room for you. There it is right there if you're in the chat room. You can pull that up as a PDF and read it so you won't think it's some type of mythology. You can go and see that, damn, they've been doing this for like 1,000 years. This is not new, putting stamps on banknotes, and they've been doing it all over the planet. And they do it whenever there is no money. I have to do this because my haters will be out there. That loud ass nigga be over there making up shit. He be moosing. That's what we used to say in our organization, moosing, making up his own damn shit. But there it is. You can go get it. You don't want to have no mythology in your mind. You can go ahead and read it right there and find out for yourself. So now it becomes real. You can take possession and ownership. You can apprehend it. All right, let's go. Let's keep reading. If the Secretary of Treasury, draw E, sends notice in writing of some error or problem, please notify the undersigned immediately upon receipt of such notice, and the matter will be addressed. You'll be notified of the corrective action taken. I hereby request that you notify the undersigned when the required time period for the Federal window and the Federal Reserve under Regulations J and Z have transpired. The ledgering completed and the account adjusted by claimant's bank. Thank you for your cooperation in getting the account settled and the claim discharged. Now, that's called an instruction letter, a processing instruction letter, how you direct somebody. You should never do a negotiable instrument without processing instructions. You have to instruct these people on what to do. You are the private banker. You are the sovereign. You are the God in which we trust. You are all these things. You have to take ownership. You have to be responsible. You have to be knowledgeable. You have to take action. You have to be proactive. You have to know what the fuck you're doing. I'll send that out on an email. You can go to radiohighfrequency.com and get on the email list. Next, we're going to talk about criminal cases. I just wanted to talk that real quick. I just touched on that real quick. We're going to talk about criminal cases now, because you can use the same process on a criminal case. But first, you have to understand that when you go into these courts, you're going into a commercial venue. Just read, I'm not even going to go deep in this. Just read 27 CFR 72.11. We'll talk about commercial crimes, all right? Okay, now, all you assholes out there, including your attorneys. If it is a commercial crime, think you would fucking use the Uniform Commercial Code? This is some common sense, is that sense, by which no other sense makes any sense at all. Now, there are two ways you can approach this. You can use a commercial remedy, or you can stay your ass the fuck out of court. I prefer the latter. I don't like going and fucking with these motherfuckers, all right? Because they crazy. They is insane. They trying to kidnap people, put people in slavery, looking at people as property, all this shit. Your mind ain't even really kind of like, prepared for how these motherfuckers think. Because you think, you still in la la land. You think it's all good. You think that everybody looking at you as like a human being. And they got a whole different damn criteria that they use of what makes you a man and what makes you a woman. Not the fact that you can eat, sleep, and reproduce. It is the utilization of your mind. Let me read this to you, because y'all think I'm bullshitting about this. There was a very good document that y'all can read. It's called Silent Weapons for Quiet Wars. And there was a real interesting statement made in this particular document, real interesting statement. Now, let me put a link in the chat room so y'all have a link. I know we got some new people. We got some new people signing in. So there go a link if you want Silent Weapons for Quiet War. But there was something that was said in here, and it related to people who don't use their mind. It says, let's talk about it. It says, it's talking about energy. Let me read this to y'all. This is about energy, because money represents energy. Everything is about energy. Energy is recognized as the key to all activity on Earth. Natural science is the study of the sources and control of natural energy, and social science, theoretically expressed as economics, is the study of the sources and control of social energy. Both are bookkeeping systems. Let me say that again. Energy, social science, and study of natural energy are bookkeeping systems, mathematics. Therefore, mathematics is the primary energy science. And the bookkeeper can be the king if the public can be kept ignorant of the methodology of the bookkeeping. All science is merely a means to an end. The means is knowledge. The end is control. Beyond this remains only one issue. Who will be the beneficiary? In 1954, this was the issue of primary concern. Although the so-called moral issues were raised in view of the law of natural selection, it was agreed that the nation or world of people who will not use their intelligence are no better than animals who do not have intelligence. Such people are beasts of burden and stakes on the table by choice and consent. Consequently, in the interest of the future world order, peace, and tranquility, it was decided to privately wage a quiet war against the American public with an ultimate objective of permanently shifting the natural and social energy, wealth of the undisciplined and irresponsible many into the hands of the self-disciplined, responsible, and worthy few. In order to implement this objective, it was necessary to create, secure, and apply new weapons which, as it turned out, were a class of weapons so subtle and sophisticated in their principle of operation and public appearance as to earn for themselves the name silent weapon. That's you they talking about. If you don't want to use your intelligence, your energy is going to be manipulated and be given to the responsible and worthy few. Let's keep going. We're going to talk about this criminal case now. What do I do when I go in court? Okay, first of all, you have to understand that this is commercial. You can stay out of the court. You can do an injunctionary letter like Jonah Bay is talking about. Or you can do some sort of notice of intent to sue. But you need to do something to let these people know your position. That you have no desire. You're not desirous to participate in their experiment called democracy, which is nothing but another name for mob rule. You don't have any desire for that. Let them know. And start with the CEOs of the corporation, that being your governor. Let them know. So you're going to stay out of the court, or if you happen to find yourself presently engaged in a court, what you want to do is, first of all, you don't want to argue. When you argue with a fiction, you're looked at as insane. When you argue with a fiction, you create what is called a traverse. When you traverse charges, you give life to what was once just a fiction. So you want to handle the matter privately before you get to court. You were giving a scripture in the Bible that talked about that. It was Matthew 5:25. Where to agree with your adversary while you're on the way to court, lest he hand you over to the judge hand you over to the bailiff, and you be cast into prison. I tell you, you should not come out until you pay the very last penny. Isn't that a debtor's prison? We're talking about money right there. You know, that's one of the other things that they're hiding from the general public. They're hiding the fact from you that you are involved in debtor's prisons. They're kind of starting to let y'all know now. You know, they put you in jail for child support. Hell, they started to put y'all in jail for credit cards and all that kind of stuff now, too. I mean, it's getting outrageous. And then they're acting as if debtor's prisons are coming back. Debtor's prisons ain't never left. It's just so sophisticated that you don't recognize it. So when you go in there and you want to argue facts, now you're giving jurisdiction, and now you are subjecting yourself to a possible jury trial or bench trial or something to that effect. You have to reach an agreement, a stipulation from the opposition before you get to court. And you have to notice all principal parties that an agreement has been stipulated to. You have to send a private correspondence to the judge, a private correspondence to the clerk, a private correspondence to the attorney, and let them know that there has been an agreement of the parties that's already been reached. If you have been giving a public defender is not a bad thing. A public defender is only bad when you don't know what to do. Let's use our common sense. Common sense is that sense by which no other sense makes any sense at all. If you are private, why are you speaking in the public? You want to avoid even talking in court if it is all possible, because you are private and you want to maintain privacy. What is the definition of a public figure? A public figure, when you look it up in a Black's Law Dictionary in the second sense of the word, it says one who voluntarily agrees to participate in a public controversy. So if you voluntarily agree to participate, you are no longer private, you're now public. And they have plenary power in the public. The superior man stays in his own domain. They will use trickery, subterfuge, intimidation, threats, coercion. They will use anything in their power to try to invade you and to coming out of your sovereign jurisdiction and come into their jurisdiction. So don't call me talking about, well, man, you know, they threatened to do this to me, and, you know, they want to give me a psychiatric, you know, examination, and I did all that shit too. You know what I told them when they tried to get, I was in jail. They were so pissed off at me. This is in the feds. I was in Atlanta, Southern District of Georgia. They were Judge Julie Carnes. She's the chief judge down there. Y'all can look her up. That was my judge. And what was it? Schofield, I think that was his name, was my magistrate. He's the one that got me the psychological evaluation. So, I come into court. They got me locked up. And I had a court date scheduled. And this was the weird thing, because these court dates, I believe they do astrology, because it was weird, because they gave me the same exact court date I had like 10 years ago. It was weird. I'm telling you, they give you your court dates. There is some type of astronomy. Because they have all your information. They not only have your birth date, they have the exact time you were born. That's stamped on your birth certificate. So, you have to be aware also that there is an esoteric agenda behind all of this. You have to understand that fact. That's why I do natural law shows. See, y'all only get half of the story. You going in there blind. You going in there 100% purely physical. There is no power at all, and the power is in the spiritual. Stop eschewing your spiritual development. And I'm not talking about religion. Take that religious crap and throw it somewhere. Do not come on my show talking about what you believe in. Spirituality is a science. And it can only be approached as such. Side of this. Okay, y'all. I'm gonna here the stamp link one more time. I'll put it in there for you. Somebody want me to put it in there. It is right there. You have to understand the spiritual side of all of this. The dates that they give you, your court dates, and you coming into the courtroom and it's empty. And let me tell you something. Sometimes you'll come into the courtroom and there'll be people in there, but those people in there, they'll be actors too. They'll just put people in the audience. And you'll see that they'll run through all their cases real fast just to get to your case. You have to have your eye, you have to be aware. You have to have your spiritual eyes open to see what is going on. This is how you're going to begin to understand and see why the Bible is a law book. This is why you're going to begin to understand that there is some sort of war going on between light and dark, between some type of agreeable and disagreeable forces. You're going to see this. The primary battlefield where it's going on is in those courtrooms. They get in souls, and there are people that are losing their soul. What do you think happens to you when you get a life sentence in prison? What type of life is that to live? That's death. They even call it death. It's called civil death. And they have it right under the word death. Anyway, I went into the courtroom. They pulled me out of my cell. I had a court date like on the 3rd. They came in, the guards came and got me on the 2nd. The reason they do this is because that's on public record what your court date is. They don't want your family or anybody or people from the outside public coming in and watching. So that, yeah, on your docket sheet, it will show you have a court date on one date. But if they find out that you're particularly knowledgeable about all this, you can rest assured that you're going to have a surprise court date, that you're going to be tested. They're going to bring you in there to test you, to see if you are of God or not. That's all the test is. All the test is to see if you are one of God's people, if you're one of the chosen. Not the called, but the chosen. Many are called, few are chosen. See if you're one of these 144,000. So you're going to be brought into the court, like they did me. And then they're going to tell you this. They're going to say, we're having this hearing in order to determine whether you are competent enough to assist your counsel with your defense and whether you know the nature and cause of the action being brought against you. Now, I'm going to tell you what I said. I ain't going to tell you what you should say. I'm going to tell you what I said. What I said was, you know what, Your Honor, you're absolutely right. I don't understand the nature of this action. Could you help me? See, I'm trying to elicit a response from the judge in the form of a yes or a no. I'm trying to get him to commit on the record that he will help me. because now he has to answer questions. Will you help me? You have to play dumb. What's one of the 48 laws of power? Play dumb. What law is that? Let me give you one. Let me give you 48 laws of power. Let me find out what law it is. Let me give it to y'all real quick. You go in there. You got to be smart and dumb at the same time. You got to be what? Wise as a serpent. You know, appear as a dove, but be wise as a serpent. Is that how they say it in the Bible? I don't know if I quoted that right. But that's what you want to do. You don't want to go in trying to demonstrate how smart you are and how dumb they are. Because anything you say can and will be used against you in a court of law. You frame everything in the form of a question. You know, I don't understand, Yana. I don't understand. Could you help me? Well, what is it you want to know? What is it you want to know? Well, Yana, is this a criminal or civil action? What am I asking the judge when I say that? Is this civil or criminal? What am I asking? I'm asking, is this Article 3 or Article 1? That's what I'm asking. Oh, and by the way, these laws conceal your intentions. Law number 3. Always say less than necessary. Law number 4. What is it? Where is that? Learn. Know who you're dealing with. That's one I like too. Law number 19. Oh, there you go. Law 21. Play a sucker to catch a sucker. Seem dumber than your mark. That's law number 21. You want to read that. So, he's asking a question. He said, yeah, okay. I said, is this civil or criminal? He said, well, this is criminal. We caught you with 50 keys of cocaine, 5 dead bodies, and 50 AK-47s under the house. Very serious charges. Going away for a long time. Okay, and you reply, well, thank you. Let the record reflect that the action being brought against the defendant, criminal. Notice you said against the defendant, not you. Now, sir, I have another question. The Constitution for the United States of America only grants this court 2 criminal jurisdictions. One is a criminal jurisdiction under the common law. The other is a criminal jurisdiction that constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction. Now, sir, for the record, would you please state under which one of these criminal jurisdictions this court is trying this criminal action? Because I have a right to know. Now, he may say, well, you know, it is not my job to give you legal advice. You may need the assistance of counsel for that. At which you would reply, sir, I'm not seeking legal advice. What I'm attempting to do is find out what your legal intent is. Now, the Constitution protects my right to know the nature and cause of this action under the 6th Amendment, and it makes it incumbent upon you the duty to reveal this information to me. So, and so I'm sure you don't want to be violating the Constitution for the United States of America, sir. Now, if he continues to refuse to give you, you say, let the record reflect that I have demanded of this court that they reveal me the nature and cause of this action under the authority of the Constitution for the United States of America, and the judge has failed in his duty to provide me with that information for the record. It has to go on the record. Also, you always are on the record. He said, first thing they're going to ask you, are you John Doe? Just say, yes. Say, yes, I am. Just say, my name is the name. My name is Joseph, blah, 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 or whatever. And then you're going to say, and that is my property, or I am the person. The name is not important. The name is not that important. What is how you are appearing in court. Appearance is what is important. The word appearance means to subject yourself to the jurisdiction of the court. Are you making a special appearance or a general appearance? The word special is synonymous with the word private. I mean, like special law. You look up the word special law, it's going to say private law. See, private law. Anything special is usually dealing with something private. It means that it only applies to a particular group of people. That's why it's private. So, only way you can make a special appearance is in your proper person. And that is what you find in the definition and the fourth edition of Black's Law Dictionary, which is a common law dictionary. Why is it called common law? What do I mean common law? A lot of people are confused about this word common law. A word also that means common law is judge-made law. The judges are the one who interpret the law. Common law is not written down. It is the application of principles, usually God's principles, to particular situations as they become before the court, but it's never written down. But you're asking this because you want to know which one. Now, usually the judges will respond, well, this is a statutory jurisdiction, at which point you ask the judge to supply you with the criminal rules of procedure for a statutory jurisdiction where you may find that, because you have to be able to defend yourself properly. Now, you can do this to prove to yourself what's going on. This is like one of the best ways to prove to yourself what is going on with these courts, because you are not going in an Article 3 court. This is not about truth, justice, in the American way. This is a money-making scheme that they are involved in. They are under a statutory jurisdiction because the United States of America is bankrupt, and everything that they're dealing with in the public are fictions of law. And they've created these legal entities in order to tax them for taxing purposes. And they made you some sort of surety for this particular entity, and through your conduct, you are presumed to be under their authority and jurisdiction by way of utilizing, Social Security cards, bank birth certificates, things of that nature. Now, what they did was they shipped me down to Florida to give me a mental evaluation. And as soon as I went in there to talk to the doctor, I don't even know if he was a doctor. You don't even know if he's a doctor. I asked him, I said, how are you a doctor? I said, where you went to school at? He told me, I said, what did you get a degree in? He never told me. He gave me that funny look. Because, they got agents, they trying to, now here's the thing you got to figure out with a mental evaluation. A mental evaluation is not always there to test your competency. A mental evaluation sometimes is to test if you one of these crazy motherfuckers who done found out the truth and you're going to go up and blow up the federal building. Somebody said they sent their discharge to the county clerk. What should I do? Read. Everything is in creditors and their bonds. Everything is in. I'm not gonna keep telling y'all that. I'm gonna tell y'all to read. Now, if you was to, this is what I like to do. If you read something and then come back and question me on what you read, that's one thing. But if I keep telling you to read something and you keep asking me questions and then I'm giving you where to read it at, that's something totally different. I done told y'all what to read. Let me give y'all this. Let me give you this one more time. Creditors. I'm gonna give you the link. I'm gonna give you the link one more time, and y'all can read this document. I done whole shows on it. I'm not gonna keep repeating myself on it. Got everything in it you need, including a bill in equity. But when you go into these courts, what you want to do is you do not want to argue. Now, if you do not have a public defender, then obviously you're going to have to speak for yourself, but you have to be very careful in how you frame your dialogue. You cannot engage the judge in too much discord. How you doing today? Fine. All this kind of stuff. Asking them, well, did you get my filing? All this kind of stuff right here. When you go in there and talk to the judge, you are acknowledging that you are public. Keep your mouth shut. And when you are spoken to, reply in the form of a question. Let them know who you are. You know, I used to always say, I'm the holder in due course. Here's a third-party intervener making a special appearance as an authorized representative for the defendant. I accept for value and return for value all charging instruments in this matter and make my exemption as principal available for all discharge of all obligations connected with this case. Please use my exemption for offset and adjustment of the public charges against the defendant and release the order of the court to me immediately. You know, say something like that. What that does is that's everything. Find you some verbiage that when you first come in is going to let everybody know who you are and what capacity you're making an appearance and so forth. Trust me, they're going to know what you're going to say. They know what you're saying. People in the audience may not know, but they're going to know what you're saying. Why am I saying I'm the holder in due course? You're the holder in due course because any negotiable instruments that are issued, you are the holder unless you don't give notice of that fact and you don't have a claim on that instrument. This is why you always put a UCC3 with everything that you do. What does UCC 3-302 say? Let me read it to you real quick. 302A, subject to subsection C in section 3106D, holder in due course means the holder of an instrument if, and I'm going to go to 2, the holder took the instrument for value in good faith without notice that the instrument is overdue or has been dishonored or that there is an uncured default with respect to payment of another instrument issued as part of the same series. Also, without notice that the instrument contains an unauthorized signature or has been altered. And here's the one, number 5, without notice of any claim to the instrument described in UCC 3-306, which is a claim and recoupment. And this is where the OID process comes in. And I'm sorry, in 3305A. Without notice that any defense or claim and recoupment described in section 3305A. So, this right here. Let me read this to y'all. I have so much I want to go through today. A lot on this stuff with these criminal cases and what type of documentation that you send to these people when you're doing a criminal case. Let me see. Do I have that? Let me see if I have it. There is another document. I'll probably have to get it on another show. I don't think I brought it over here to the office with me. But what I wanted to do is there was when we talk about these GSA bonds, that's another thing that you can do for your cases. There's processing instructions that go with those bonds as well. And they're very, very, very involved instructions as far as, and like I said, you don't ever give negotiable instruments without giving processing instructions and also without some sort of notice of claim to those particular instruments because you're the holder in due course of those instruments. You are the one that all money is derived from. That's why they need your signature. That's why they need your voluntary consent. That's why they're always trying to get your signature on something because you are the one that creates money. You're the private banker. You have the power. You have the keys, but you have to know the rules to the game because if you don't know the rules to the game, then they will steal your energy or steal your labor and utilize it against you. There's also, now I'm going to tell you this, there's also another one, Judge Dale. This is where everybody got this from. This is for all my new people. And you can try this too in court if you got to speak for yourself. There is this document on the internet. It came out some years ago and was talking about appointing the judge as the trustee. You can do this. Yes, you can. You can do that. But there is something that you have to pay attention to, because like a lot of people, there's what people do. I notice what they do. They go out and try this stuff, but they don't read. They don't pay attention to things. I'm gonna give you an example of what I'm talking about. Like people, I went out and tried to appoint the judge as the trustee. It didn't work for me. Let me show you. Let me show you what I'm talking about. What people don't do. Let me find this. And you should read this, because everything in this great American adventure right here, let me put this in here, is on point. I don't know if this guy is a real judge or not, but, you know, he got some, you know, I know where a lot of the information, I can cross-reference a lot of the information. And where's this thing at? Hold on, let me pull it out of here. I want to read this to y'all, because I want y'all to see what I'm talking about as far as when people get information, they don't read everything. You know, I read like Creditors and the Bonds. I read that stuff for like 2 years. Wasn't just something I just read one time, and you know, I read the thing over like 200 times. Then you're gonna read something one time, you're gonna understand it. Are you serious? You got to read something at least 7 times before the brain cells in your mind start to formulate and can accommodate the information that's being conveyed to you. You got to read something repeatedly. Let's see. Where is this at? Using your attorney. Okay, yeah, that's the name of the document is The Matrix in You. And they hid the name of the person, but I think it's Judge Dale wrote this. But it's called The Matrix in You. And it goes, right. Okay, right here. All right, this is on page 16 at the bottom. It's like when you appoint the judge as a trustee. I'm going to give you an example of how people don't pay attention to everything. They just do not pay attention to the spiritual aspect of things. It says, under our corporate government, no sovereign can lawfully be tried or convicted of any statutory crime. I recently discovered how to avoid prosecution under the trust when a sovereign is taken before a corporate prosecuting attorney or a judge. First, the sovereign must inquire if we are on the record, and if not, insist upon it. Say nothing, sign nothing, and answer no questions until you are convinced that the proceedings are being recorded. Now, I tell everybody that all the time, and people come back to me and I ask them, were you on the record? Well, no. I mean, you can get jurisdictionary, and that attorney over there tells you that the judge is going to kick you in your fucking ass if you're not on the record, because you can't run and go tell nobody nothing. So the first thing you always got to establish are you on the record? Is this being recorded? Secondly, all a sovereign has to say for the record, I am a beneficiary of the trust and I'm appointing you as my trustee. Thirdly, the sovereign then directs his trustee to do his bidding. As my trustee, I want you to discharge this matter I'm accused of and eliminate the record. Fourthly, if the sovereign suffered any damages as a result of his arrest, he could direct that the trust compensate him from the proceeds of the court by saying, I wish to be compensated X amount of dollars in redemption. Now listen to this. This statement is sufficient to remove the authority and jurisdiction from any prosecuting attorney or judge. The accused will be immediately released from custody with a check, license, or claim he identified as a damage. It doesn't matter what the action involves or how it is classified by the corporate law as a civil or criminal action. It works every time. All of the codes, statutes, and regulations throughout the United States are a will from the masters to their slaves. A will is defined as an express command used in a dispositive nature. When individuals in America are charged with a crime and warehoused in a jail, it is because they went against the will of the masters and not because they harmed another person. Remember that the will demands from us all that we are, keeps us in check, and promises us nothing. And I want to read this part too. I was looking for the part where it's talking about. It said that you got to be able to stand and not to be shook. I'm looking for it. I think it's in the other one. But in this also, this is what you have to do. You cannot allow yourself to be shook. Because when you make a statement in court, they are also looking at the way that you make your statement. They're analyzing you. They're looking and seeing whether or not you're afraid, you're shook, whether or not you're just parroting some information, somebody's talking. You have to be conversant with this material, and you have to be confident in this material. Those are variables that a lot of people do not take into consideration. They're just looking for the magic words. Tell me what to say. It's not what you say, it's how you say it. It is the spirit that is contained in the words that you're conveying to whoever you're directing them toward as well. They got to know that you're not bullshitting. That you can really do what you say you can do. Not that I was listening to high frequency radio and Yusef told me to say this and the shit didn't work. This is not for everybody. Y'all got to understand that this is not for everybody. When I first started my show years ago, that's what I told everybody. I said, look, this is not for everybody. This is for the worthy few. All right, those who have the spiritual power to be able to see what's going on and be able to stand firm, able to stand on a square. It's not for everybody. It's not for people with weak constitutions. It's not. It's not for people with weak constitutions. All right, it's 10 a.m., so I'm going to stop right here. Now I'm going to go to the phone line. But I'm going to take a quick break first. I'm going to take a quick break, and after we take this quick message, I'll be back. And we're going to go to the phone line. The number is 424-222-5250. You're listening to the hottest radio network on the planet, High Frequency Radio, y'all.
You're listening to Yusef on the baddest radio network on the planet, High Frequency Radio. Doing this thing all the way live, High Frequency Radio.
Do you want to expand your conscious thinking to become a better individual? Learn more about public and private, filing a UCC? Or do you simply want to become a healthier version of yourself? Visit our website at radiohighfrequency.com. Click on the store link for products, webinars, services, and more. You never know what jewels you might find. So just visit our website, radiohighfrequency.com. Click on the store link.
This is Dr. Naila Bakari Gilliam, host of Reawakening Minds, heard Mondays 9 p.m. Eastern, 6 p.m. Pacific on High Frequency Radio Network, inviting you to join me and my guests for lively topics of discussion ranging from the practical to the metaphysical and all things in between. I invite you to call in, log on, or simply listen as your mind is stimulated, your consciousness is expanded, and you are introduced to the limitless possibilities and realities of the universe. I am here for you, and my mission is to reawaken minds one mind at a time. Are you awake yet?
Hello, folks. This is Dave McDowell coming to you from the great state of Texas and High Frequency Radio. I want to thank each and every one of the listeners that come out and listen to my show. And I want to say that I'm on every Wednesday from 12 to 2 Central Standard Time. And I look for each and every one of you to show up. I appreciate all the callers that call in, and I hope I can answer all your questions. Until then, have a great day.
Do you need help with a court case, filing your UCC, authentication of your birth certificate, creating a trust, drawing up a business plan and goals, or do you simply have questions? High Frequency is here to help with an array of dedicated scholars. We value our professionalism, and we understand how important it is to come through for our listeners. Do you need to schedule a private consultation? Visit our website, radio-highfrequency.com. Click on the Donations tab. Schedule your consultation with one of our ministry members, Yusef, Jonah Bay, Isa, Dave McDowell, or QLE. Just visit our website, radio-highfrequency.com. Click on the Donations tab. Select your ministry member, and your consultation will be scheduled. And of course, if you have any questions, feel free to email us at info@radio-highfrequency.com. So schedule your consultation today.
Doing this thing all the way live. High Frequency Radio. You're listening to High Frequency Radio Network. Connect with us at radiohighfrequency.com. You're listening to Yusef on the baddest radio network on the planet, High Frequency Radio.
All right, y'all. Peace to the gods. I'm back. Yeah. You know, I was gallivanting around the country the last 2 weeks. I was in Vegas, you know, using my U-Box. You know, I watched, you know, I call it the crack box. It's the crack box, y'all, because if you haven't, like, looked at some, like, I had never looked at Power before. But I turned on the crack box and I watched the whole damn season in one night. I just watched the whole season in one night. It's the crack box, y'all. That's what we call it now. It's like crack. You know, you only watch TV this much, but this will have you watching TV. Because there ain't no commercials, you know, none of that stuff. You just watch what you want to watch, man. I'm telling you, anybody who gets that box, they're going to co-sign what I say. Y'all need to check us out, radiohighfrequency.com, y'all. But anyway, let me go to the phone line. Calling number is 424-222-5250. Call in right now. I'm going to answer your questions. Let me start off. Go to Arkansas real quick with Sister Ashley. I'm going to give you some feminine energy. Let me bask in this feminine energy. Welcome to the show.
What's up, Yusef? How you doing today?
Doing all right. How you doing?
Well, I'm okay as long as you don't fuss at me because I have a question I want to ask. Since you was talking about, you know, discharge.
That's what it's called. You know, answer the question. I ain't going to fuss at you. Go ahead.
Well, you was like, y'all don't read. You was like, y'all motherfuckers don't read.
I mean, that's what your mom and your daddy would say. I mean, that's what I was saying. You know, that motherfuckers need to go in there and get your schoolwork. Do your work. Shit.
Well, this is my question. I got two questions. But the first one is, you know, I want to be responsible and worthy and sovereign and all this. But I did a thing that I don't know if I can get out of. I actually filed bankruptcy. But I have not went to my bankruptcy court hearing. So I'm wondering, is there any way that I could, like, back out of this, you know?
Did you do a 7 or 11?
You mean
you do
7
a 7
or
11? Yeah, I mean a 7 or 13. Yeah.
I can't remember exactly which one it's called, but it's not the one where you give all your stuff away. It's the one where you consolidate.
Yeah, that's a 13. But if you do a 7 and if they find you have any assets, they make it very difficult for you to get out. They're coming to arrest your ass. But with a 13, you just don't do the proper filings and you can get out. But a bankruptcy is not always a bad thing. I mean, you can get remedy in bankruptcy a lot of different ways. I mean, it depends. What do you file bankruptcy for?
Well, basically, it's just a car and just some old debts that I had that I needed to get rid of.
Right. Well, let me say this, because you're just reorganizing, you're restructuring yourself.
Right.
There is a document, and Judge Dale has it. He talks about bankruptcy, discharging debt in bankruptcy, utilizing the birth certificate. But in order for it to be effective, you're going to have to get the CUSIP number, because you have to be able to prove and demonstrate on the record that there is value behind that birth certificate, and that's demonstrated by having a CUSIP number. Now, I'm just putting this out there for the general public so they can, kind of be apprised of that information. Because once you put that on record and everything, you can direct them to you, because that's what bankruptcy is for. Bankruptcy, they put all of your property in trust for the payment and payment of debt for creditors. So if there's some sort of negotiable instrument that has been, placed, put in there, you can direct them to use it. That's what it's for. It's for setting off debt. So that's one way of doing it, Obviously, there is also the challenge to the creditors. You can take them into an adversarial proceeding in bankruptcy and make them provide some sort of verification of that particular debt. Because, see, they have to all fill out a B-10 proof of claim form, which is like an affidavit swearing that you owe them some money. And at this point, you can subpoena Duces Tecum, their particular records, in order to find out if there is an actual debt. Because usually what they're doing is they're drafting you for performance on the receivable sides of that accounting ledger. They're not bringing the payable side in. With this, you got to understand accounting. You got to understand what an all-balance sheet is, what all-balance sheet accounting is, what a FR 2046 is, what the matching principle is. This is why you need to read the affidavit of Walker Todd. Once you understand these things, you can take them into an adversarial proceeding, and you can challenge their position as creditor. So there are different methods that you could utilize. Bankruptcy is not always a bad thing. It actually is a very good place to make a stand against creditors.
Okay, well, I'm going to have to do some research because I don't feel like I'm in a good position, but I would like to take no, because, I just, even though I know the first rule is there is no money, but shit, I want my money. I go to work every day.
Let me say this. When I say there is no money, that does not mean that we don't have a medium of exchange. There is a medium of exchange in existence that we utilize. When I say there isn't any money, what I mean is there's no substance-backed currency, all right, in the form of gold and silver that's been constitutionally authorized. What we have now is we have a different jurisdiction that they're operating under that is outside of the Constitution for obvious reasons, and they're contracting people into this jurisdiction by way of the birth certificate and Social Security card, and they are issuing you monopoly money to engage in commerce every day. It is perfectly lawful what they are doing. I wish people would stop saying it's illegal and unlawful. They have the authority to do this under the Act of 1871, and there's plenty of common law court citations to support it. Now, these idiots on YouTube are saying this, but ain't not now one of them made you a video going into the law library showing you where this shit is, did they?
No, they sure did not.
Not one.
Well, I'm just going to have to, what I'm going to have to do is get some webinars so that I can get some info on this stuff, but I just wanted to know.
You need to get a private consultation. That's what you need.
Okay, so I just go to info and because I will get a consultation because I need to know.
You need to know. Well, why don't you hit me up? Why don't you hit me up at highfrequencyblogtalk@gmail.com? Just email me, okay? Email me at highfrequencyblogtalk@gmail.com, and I'll go over some of the more salient points of your particular case. And then I can tell you what we can do for you from there. We can kind of talk on that a little bit. I don't want to talk too much about people. Yeah, go ahead. Go ahead.
Okay. How do you get in this chat room? Because you always talking about what you're going to put in the chat room.
You got to sign in, man. Right when you click on the link, you're going to scroll down. It's going to ask you to sign in either from Facebook or get you if you got a Facebook account, just sign in with your Facebook account. And then you go down there, and then, you can participate in, what's going on in the chat room, because there's information I'm kicking down there in the chat room. Look at our chat room. We over 100 people in the chat room. Wow. I got to keep it at that. I got to keep bringing this fire.
Yeah, you do that, but I think that's all I really had. I can't even remember what my password is. I see my picture and everything, but I don't even know.
Password is, man, girl. Well, email me at highfrequencyblogtalk@gmail.com, and I'll help you figure out your password too. How about that?
Well, let somebody else come on with their question.
All right, baby. Appreciate it. Thank you for calling.
Right. Thank you.
Peace, got it. Calling him that sexy voice. Those sexy ass voice. Women. Love a woman with a sexy voice. Do I need to talk to some men? I like talking to sisters. You know what? I'm gonna bring in. I know this individual is gonna be interested. So I'm gonna bring him in. Perfect Black in PA. What's happening, bro? What's going on? What you got for me?
How's everything with you, Yusef?
Going good. What's happening? I know you're gonna hit me with some questions. So let's roll. Hold on, let me get my pistol. Oh, let me get my pistol. Load this. All right, go ahead.
You my first teacher, right?
All right.
So as soon as I heard you talking, you were the first voice, and Savage the second voice. So y'all my first two teachers. You know what I'm saying?
Right. Appreciate it.
I gotta give you guys props. But again, I always say you're the master of word meaning and breaking shit down. It's like, you're like a double barrel shotgun. You gotta break it down to put some shells in it, and you break that stuff down real quick.
Man. You gotta break it down. Well, what you got for me, bro?
Well,
what you got?
Well, I got probably two questions. I always got a lot, but I'm gonna have to get a consultation with you. But those writs, like a writ of quo rento, a writ of mandamus, and like a writ of error. Now that writ of quo rento and a writ of mandamus, the procedure for that is like if you have a problem with a public official, they gotta come like to court, like by what authority are you doing what you're doing? How exactly does that work from your experience and knowledge?
Well, it's just that you're establishing their delegation of authority. That's what a quo warranto is. Quo warranto means by what authority are you doing this? A mandamus is a directive from a higher court to a lower court of an inferior jurisdiction, directing them to perform some action that they're required to do. And a writ of error, which is a very. I just did a webinar on a writ of error not too long ago. Is when, say for instance, there is I'll give you an example like the one that we did, where you had a trustee somebody sued a trustee, but in the contract it was very clear that the trustees were immune from prosecution. So there was an error. There was a defendant in error, and then there was a plaintiff in error. So it was an error, and that was being pointed out by the defense. That this is an error because right here, and the contract tells you specifically what contract makes the law, and the contract has directed what is what, and it was going against it. So, that's what those are. And one of them, you only have four major writs, and those are mandamus, prohibition, habeas corpus, and prohibition, mandamus, habeas corpus, and a writ of. I forgot the last one.
I think you said them all.
Four of them.
I thought you did. Yeah, you said the habeas corpus, the mandamus, the error, and quo rento. I believe you said them all.
No, mandamus. It's not quo warranto. Quo warranto is not a major writ. It's prohibition, mandamus, habeas corpus. I think it is a writ of error. It might be a writ of error. There's four of them. I forgot the last one. Can't think of it right now.
The prohibition is like by what authority also, right?
No, it's prohibitive conduct. It's just what the word says. It's prohibiting somebody from doing something that they're not supposed to, like people going out, giving false information. It's just what the word is. It's a prohibition. which is stop you from doing something that the law, that the law says you can't do, prohibiting you from doing something.
Now that both of those writs, would those be filed in like a superior court?
Yes.
Or what court would?
Someone who has the jurisdiction to issue them.
Okay then. Well, like in a regular,
like a mandamus. I mean, you're not going to get a mandamus out of of an inferior court because it's a writ for a superior court to issue to a lower court. And mandamus are not very easy to write either. They're not easy to write. But go ahead.
Okay, but you can write one if you want to. Say if a public official isn't doing what he's supposed to do, you can write one and file it with the higher court. How does that? Is that basically how it works?
Well, you can apply for one. You can apply for a writ.
You apply for one.
Yeah, you apply because the judge is the one who's going to issue it.
Oh, okay then. And their basis. Okay, so most writs you apply for them basically.
Yes.
Okay. No, because when you went to the law library, because I'm gonna go,
That's what it's called. It's called an applicant pleading.
Okay. All right. That's why I talked to you, because you break it down. I'm gonna have to get that webinar you were speaking about when you talked about the writ of error. I'm gonna have to get that from you. And I guess last but not least, what is admissible evidence? Like basically on recoupment and what's on the payable side. What is admissible evidence?
Well, anything that's been notarized is admissible. Anything notarized.
Okay, my next question.
And all certificates from notaries. Those are admissible evidence. And the only way that they can be controverted by parole evidence, which means oral, is through a jury trial.
Okay, anything notarized, that's basically like an affidavit, but that's still like an out of court statement.
Affidavits can be controverted though. You could be subject to cross examination with an affidavit, but it is admissible. It's sworn testimony. Evidence comes in a couple of ways. You have a deposition. You have an affidavit. Then you have sworn testimony in open court, and then you have notary documents. It's like 4.
Okay. Now, the question I was going to lead up to now, that affidavit of Walker Todd and A.K. Arnold's deposition, which is all part of other court documents, would that be like admissible? Because I remember you said you put the affidavit of Walker Todd.
I'm giving you direct experience. I put it in my case, and the judge tried to remove it, and I just told him, I said, well, I wanted amended. I wanted amended to my complaint and as a citation of authority. I mean, even though it is kind of like dicta, what they call dicta, D-I-C-T-A, is dicta because it's coming from another jurisdiction. They're not required to follow anything from another jurisdiction. But here we have someone who was the head man for the Federal Reserve that's telling you what is money and what is not money. Because they don't have to follow opinions from other jurisdictions. That's why a lot of people out there, they'll just arbitrarily pull out case citations from all over the country and expect it to be effective. It don't have to be effective. You got to pull case citations from that particular jurisdiction if you want the judge to take judicial notice of it. If not, they have a choice. It's called dicta.
Okay. Now that if those court citations are coming from that circuit court or that district court, I mean, they would have to follow that, though, right? If you're saying
it's what they said. It's what they said. Why wouldn't they? Why wouldn't they follow their own pronouncements?
Oh, okay. No, I figured that was the higher court, because most of the stuff I got jurisdiction there because you told me to get it about a year and a half ago. You didn't tell me to get it, but I heard a lot of people talking about it, and I really didn't get it. But when you said it's good, I wouldn't have got it. You know what I'm saying? Yeah,
so, you're talking about that jurisdiction. Yeah, jurisdictionary, I think is real good. And you should get on their email list because they send a lot of interesting emails out too. They give you some good principles, as far as how to conduct yourself in court.
Oh, okay. All right, well, that's just about it. I'll let somebody else get in. I had one more question, but I don't want to hog the show. I'll probably catch you on another show.
Okay, appreciate it. Thank you very much for your call.
All right, my man. Thanks.
My man. All right. I always got to get hit with some test questions, y'all. I got to stay on point and hit me with the test questions. Let's see if he know this. How many of y'all know what dictum is? Write that down. D-I-C-T-U-M, dictum. You should know what that means. Put that in your vocabulary. Dictum, dicta, D-I-C-T-A, or dictum, D-I-C-T-U-M. Those are opinions of judges that are not binding. Need to know that. Let me get some feminine energy in here. Sister Tanya in Georgia.
Hi, Yusef.
Hey, what's going on, babe? What's going on? What you got for?
Nothing much. I just have a quick question. I have heard topic, and I would like to know what you know.
Okay.
Or if you possibly. I've heard rumors.
I don't know.
That...
I don't know. Oh, I'm sorry. Go ahead. Go ahead.
I've heard rumors. The provost marshals are in charge of all these districts, but no one that's out here saying that is really being specific as to who that is. So I would like to know, is that possibly the sheriff of the county?
Possibly. Well, for that district. Now, the provost marshal, I've heard the same thing. Now, when you get, I gave everybody a document called, it's called Law Redemption in Court. Law Redemption in Court talks about contacting the provost marshal to get specific things done, so you can contact them. I've never done that myself, so it's hard for me to speak on something that I haven't done. However, yes, I'm very much aware of what you're saying, and I'm directing you to a document right now that talks about the provost marshal, and that's Law Redemption in Court. It talks about the provost, contacting the provost marshal in the county. Also, believe it or not, who is that in there that checks the dead people? I'm trying to think of the name.
Coroner?
Coroner. The coroner is somebody else you want to contact too, because the coroner is the one that forms a check on the sheriff.
Right, I read that actually, and it kind of threw me for a loop. I'm like, what does the coroner have to do with the sheriff?
Exactly. I mean, I didn't understand it either, but it's true. And it's also, I heard that they keep records down there. It made sense to me if you understood that, like, when you get a charge, you're considered dead. It's called civil death. So
right.
I could understand it. I can understand how they would be involved in a kind of, but right now, everything I'm saying is kind of like speculation. I don't really have anything substantive to support what I'm saying. So that's kind of the best I could give you on the answer for that question, and kind of direct you in some places where you can start investigating it. But I have heard about the provost marshal. Yes, I have.
Okay, so then what is the role of the sheriff? Like, property, protection of property. I've read the code. I've read the
He's the constitutional.
So I'm trying to figure out what.
He's the constitutional authority on the state level for the enforcement, the enforcement of orders and everything. He is the constitutional authority as the sheriff.
Okay. Well, all right. Well, that's pretty much. I'll just go read Law Redemption.
And let me say why. Let me give you one more thing with the provost marshal. The provost marshal, a lot of this is militarily related. So you're going to hear a lot of people give a lot of different remedies that are kind of militarily related. Like there was this thing, escaping my mind right now. But because you have this military jurisdiction, this is why you have all these district courts, because of the Civil War, and there hasn't been any declaration of peace or anything like that. So these are kind of like military districts that we're involved in, and that's why they're directing you to the provost marshal. because he's the person in charge of the military police. So that would be.
See,
yeah, go ahead.
Yeah, and see, and I get that because I've read like many of things on the Reconstruction Act. I've followed Keaton, and he explained that the Civil War never ended. So, I get why we have like all these districts, and we have military stations, things of that sort. Just trying to get clarity. How would you find the provost?
Okay, let me. Okay, I'm gonna tell you, and I'm gonna direct you to clerk's practice, and also go into American jurisprudence on admiralty, because this is admiralty. And admiralty, the bonds go to who is ever the custodian of the property. So, like the sheriff on the state level, when you get put in the county jail, you're really under the custody of the sheriff. That's why when you do a habeas corpus, you got to do it against the sheriff. All right, you're doing it against, because he's the custodian of you. All right, so
right. Okay.
So the provost marshal, in a way, he would be the person, like on the federal level, that has you in custody. Now, the reason that you contact the provost marshal, because his little underlings, when you start giving them like bonds and things to let you out of jail, and they don't want to do it, you always got to talk to the chief heads and let them know what their subordinates are doing. Say, look, man, you supposed to. It's just like when you go. I'll give you an example. I called T-Mobile. I paid a bill, and it didn't appear on my bill, so I called T-Mobile. I went into like one of their stores and paid, and it didn't appear on the bill, and I had a receipt and everything. So I'm calling T-Mobile up. I says, hey, man, because they sending me a bill telling me they're going to cut off my phone if I don't pay the bill. So I'm calling them up and say, look, man, I already paid the bill, man. You need to check yourself. So the customer service agent say, well, look, this is what I want you to do. I want you to go back up to the T-Mobile. And I said, man, I ain't going no damn where. You want me to jump in my car and go back up to T-Mobile because some incompetency of your people? I got to spend some gas? That's not happening. He said, well, sir, I said, look, that shouldn't even came out your mouth. You don't tell me to do nothing. That's customer service. You go and do it. Matter of fact, let me speak to your supervisor. Supervisor couldn't help me. Let me speak to the manager. Got to the manager. The manager, no, he don't want it to go no higher. Because I'm going to the director, and then by the time it gets to the CEO going to wonder, why in the hell is this bullshit on his desk? And why it wasn't taken care of. You know what I told the manager? I said, look, man, you know what? I'll just go file a lawsuit against y'all. It's only going to cost me about $200 to do. I might even lose the motherfucker. But it don't matter because y'all going to spend thousands of dollars trying to take care of this little $200 damn bill.
Right.
It didn't cost me nothing to go down there and file an action. I'm going to serve you. You got to answer. You got to go get your legal department, pay them about $200 an hour to sit here and address me with this bullshit. And, every time I say that, I always get what I want. Because they know I'm telling the truth.
Right. So you're saying that,
So, yeah, in other words, you contacting the provost marshal, these are people that are in charge. The underlings ain't never going to do what they supposed to do because they don't know half the damn time. The provost marshal is the provost marshal for a reason. Just like you got a CEO and a CFO. The only people who know how to discharge debt of the corporation are the CEO and the CFO. Vice presidents and none of them know that, especially at a bank. They don't know. You coming to them with certain information. They don't know what the hell you talking about. The only people that know what's going on are people in charge. Them is the people that are delegated. Go ahead.
Right. So the provost marshal, you're saying he is actually over the sheriff and everyone else in that district.
Well, he's like a sheriff within his own military jurisdiction, and he's over the military police.
Oh.
And let me say this. It's like, and then that's why you got to know this is militarily related. And the reason I'm directing you toward the clerk's praxis, because in the clerk's praxis, it gives you the procedure for getting out of jail. Now, in the clerk's praxis, they don't use the word bond. They use the word caution. All right? Today they use the word bond, but in antiquity they used the word caution, that the plaintiff and the defendant had to put in a caution, and once the caution had been placed, then the property had to be released. This is why you have GSA bonds. You have a 90 and a 91, a 24, 24, 25, and 25A, because those bonds are supposed to take the place of the property. This is why when they give you a bail bond when you're in jail, they won't let you out of jail until you have some sort of bond that will take the place of the property. This is the whole reason for bonding cases, to make you immune from prosecution, to make you immune from them taking your body into custody, doing what's called a body execution, and then taking your body and holding you as collateral on something, because you've already collateralized whatever the obligation is by the use of your bond. This is why bonds are so important. This is why I keep directing everybody to a document called creditor and their bonds. But you got to understand that this is all about bonds. And who the bonds go to, and who the bonds go to. In antiquity, the bonds go to the sheriff or the marshal, because they're the ones who have you in custody. That's why you contact them. That's why they're involved in the mix, because they're the ones keeping you in custody.
Okay. So we in turn really could take those, because I know at the state level you said it's the 224 and the 225s, right?
Right. It's like you talking about a habeas corpus?
Take the actual. Well, no, yeah, because I have some property that's being withheld from me,
right?
AKA children, and so instead of filing it into the, actually take it to the sheriff, right? I mean, if he's the one that that's where the bond.
Well, I mean, if something is being warehoused, I mean, if we're talking about children, they're not in jail, are they?
No, they're just being held in naked possession by the family members.
No, you would need to find out. I'm sure that would be going to the clerk, because the clerk also gets the bonds. The clerk is one. And this is why I haven't read it in a while. I need to go back and read it again. I'm going to tell you how my methodology and study, how I went about studying things. What I did was I went and read clerk's practice first, and then I went into a law library and read Admiralty and American Jurisprudence. And that way I got the historical foundation first from clerk's practice, and then I got the modern or contemporary way that they do things, and then I can point out all the changes that they made, because they got a slight change on who those bonds go to a little bit, because they're doing the same thing. The principle of operation is the same of what they did 200 years ago, but the words have been changed. The designations of titles have been switched around, so it gets a kind of little confusing, and requires you to do a little bit of study. But I'll go ahead and investigate that for you. But I'm just giving you the provost marshal, his involvement in all this. The reason for that is because whoever is in custody of the property, you got to understand what property means too. If you want a release of a lien on that property, because that's what they're doing, they're liening the property, and they're executing on the lien by seizing the property. So if you want to release on that lien on property, you got to know who is the proper person, who is the custodian of the property, who is required to release that property once it's been bonded. That's it, really, in a nutshell. I can make it sound very, very eloquent and complex, but it really comes down to that: who's in custodian of the property and their requirements for release of that property after it's been bonded.
Right. Okay, so the provost marshal, you're saying I could go read, what was the reading again? I think it's something. You know what? I'm gonna do a show on clerk's practice. It's gonna be long though. It's not gonna be one day, and what I'm gonna have to do on clerk's practice, I'm gonna have to send out like 200 words of definitions, because if you are not the type of person that looks up words, you'll never get through clerk's practice. Clerk's practice, it took me 6 weeks to go through that document. That's why I haven't done it, because it's like reading all those words. That's a lot of work in that particular document. But I see that it's going to be necessary. It's going to be necessary for me to do it. So I'm going to have to do like a series of shows where I'm just going to go line by line through clerk's practice. I got to do it, because people hear me talk about it all the time. So I'll do that. Right.
And I'll read it over the air.
Right. And also, I have another question, and I'm going to let someone else get on.
All right, go ahead.
I had a question about like the clerks in court and stuff like that. Are there, like, how do we know what their job is? I was thinking the clerk's practice, really lays it out, but is there somewhere in our statutes, that we could, in our state statutes, that like kind of iron out their procedures?
Yes, it is.
What they're supposed to do?
Yes, it is. Everybody has a delegation of authority. Everybody in the public. So, yes, you can find it out. Everybody has a delegation of authority. So, yes, the clerk. Yeah, the clerk. What state are you in? Let me see if I can find it right now.
Alabama.
What state? Oh, yeah, Alabama.
Mm-hmm.
Title 12. Let's see. Courts. Title 12 in your state is the courts. And let's see. And it might be 4A. Employees of Supreme Court of Appeal. Judicial inquiry? No. Let's see. Uniform circuit courts, district courts. Let me see. We got district courts down here. But everybody has a delegation of authority. They have to have it.
Right.
Traffic offenses, appeals, general provisions.
Yeah, because I was.
Go ahead.
Yeah, because like I do a lot of studying, so it kind of seems like if we don't know what the clerks are supposed to do, you're kind of screwed because like they can play little games. So the clerks play their little games too.
Yeah, they do.
Turn blind eye to a lot of things, and it's just I feel like if we all just get knowledgeable about what it is their jobs are. What their job is and what they're supposed to do in certain situations, so that because how can you really hold someone accountable for what they do or they don't do if you don't know what they're supposed to do? If you don't have a reference point, like maybe something in the statutes, or I don't know if it's in clerk's practice, or whatever, that you can just rely on yourself and say, hey, if I file this, the clerk is supposed to do that. The clerk is supposed to do this, that type.
You do find it. Go ahead.
Like, for instance, when you're telling us about the bonds, like all the cases need to be funded, like we're dealing with a child, like sources, child care stuff or whatever. So Are you saying in all cases, no matter whether it's a criminal, well, all of it's civil, but if you're dealing with a child care case, drug charge or whatever, you're saying we need to,
all cases have to be bonded.
We need to go in.
Yeah, all cases have to be bonded because the statutes, if it's statute related, the statute is a representation of a debt. When you find this, all goes back to the Bible. All right, this goes back to. I'm gonna tell you what verse you need to read too. It's Leviticus. I'm gonna tell you right. I want you to put this in your mind now. I want you to put this in your mind. This comes out because you got to understand the Jews are behind this. This is why you see them as all these chief judges in all these courts and everything, because it's their laws that are being instituted against us because it's who we're in debt to. When you look at the Federal Reserve, Ben Bernanke and Alan Greenspan, them all Jews, and the Jewish Sheetar. You got to get this is about debt, and the people who instituted this debt, this interest, and all this guy were Jews. It's the Jewish Sheetar. So it says out of Leviticus 25, you go to Leviticus chapter 25, because all this stuff come out of the Bible. You got to know this. You got to know it comes out of the Old Testament. And when you read this, it's going to tell you. And you got to think about this now. Think of yourself as Jewish and everybody else being a goyim or people who are not under the law. Was it 25:45? Yeah. It says, let me start at 45. Moreover, the children of the strangers that do sojourn among you, of them shall ye buy, and of their families that are with you, which they beget in your land, and they shall be your possession. And you shall take them as an inheritance for your children after you, to inherit them for a possession. They shall be your bondmen forever. But over your brethren, the children of Israel, you shall not rule one over another with rigor. Okay, now if a sojourner or stranger wax rich by thee, and thy brother that dwelleth by him wax poor, and sell himself unto the stranger or sojourner by thee, or to the stock of the stranger's family. After that he is sold, he may be redeemed again. One by his brother may redeem him. And this is why they call it the redemption type process. You're redeeming yourself from this debt that you have incurred that has put you into a form of slavery, because that's what slavery is debt.
So on the state level, when we're
go ahead.
Okay, the state level, when we have any type of charges or dealing with any type of court case, what are the SF forms? Is it the 224 and the 225 and the individual affidavit of surety that we need?
No, well, let me tell you something. You can use any instrument you want. When you use the SF form, SF stands for standard form. They standardize something. Right. You don't have to use those forms if you don't want to. You can use any sort of negotiable instrument you want to. That's why you have a uniform commercial code. It shows you how to draft up. If you don't know how to draft up a negotiable instrument yourself, we have some standard forms that you can use. You see what I'm saying?
Right. Okay.
That's what it is. All right. So that's why I teach negotiable instrument classes, to teach people how to make their own negotiable instruments, to do it in a professional manner, because they are going to take these instruments to trade, because you're not going to get them back, all right? And they're going to take them to trade. Right. So everything has to be bonded. Everything is about debt collection. Everything is about you satisfying the debt. Everything also is about contempt. And in the clerk's practice, they do not use the word contempt. They use the word contumacy or contumacy. You can look that word up, contumacy. That is for contempt. You're in contempt of court. The reason you're in contempt is because they've given you a straw man. When you read your secured party process, you will see in there that you agree to discharge all obligations incurred by your straw man. So why are you going to go in there and argue? The United States needs you. They are bankrupt. Right. What are they going to do if everybody in the country decides not to help them anymore by putting their signatures on things? They're going to go out of business, and they're not going to let that happen. So you don't want to be looked at as an enemy of the state. This is why I teach this. This is why we talk about going in and doing what's called an acceptance for honor, where you honor the court, or coming in as what is called a stranger. Look up the word stranger about in the third sense of the word. You'll see that it is a person that pays another person's debt. They may call you a stranger in court one day, and you may think it means something else. It doesn't mean what you think it means. Look the word up. What a stranger is.
Right.
Everything I teach is about honoring the system and satisfying the obligation. And you do that with mortgages or whatever you're going to do.
And that's why I asked those questions about the bonds, because, like, I already know that this is like a test, so it's not, like, I just want to do it right. I just want to pass my test, and I want to do it right. And that's all I'm interested in. I'm not interested in all this conspiracy stuff or this and that. I don't really think the government's against anybody. Just pretty much I think they want to know where you stand on stuff and if you know who you are, really.
Right.
And that's why I was asking, about the SF forms, because if we're not going to do the performance, the payment, and the individual affidavit of surety under the SF, what are our own forms that we need to draft if we're wanting to, put those bonds into the cases like we're required to, and then we need to mail that to the clerk.
Yes, it's a number of different things you could do. I mean, if I were going to send anything to clerk, I'd use the standard forms. That's just me. I use the standard forms, and it's how you send it to them. You got to send it to them in private. So that's the thing is that people, they mail things to the clerk. They mail it in their public capacity, and they don't use a restrictive endorsement. The restrictive endorsement lets you know that it's private. The clerk is the one that gets the bonds, not the judge. It is the clerk that gets the bonds, because the clerk is the one that's responsible for it.
Right, and that's why I was asking that, because I want to make sure, I know it goes to her, but just how to send it and,
restrict anything you send private is restricted. Anything you send private is restricted endorsement. Restrictive endorsement means that the only person who's going to see that is the person whose name is on it. That's how you keep something private. And then you write private communication on the outside of the correspondence. Let her know it's private.
Okay. All right. Well, very good. Thank you, Yusuf. I'm going to let someone else get on. And then I wanted to, one more thing, the clerk's the reading for the Provost Marshal. What was the name of that document again? I'm sorry.
I was telling you to read the clerk's praxis and the American. If you want to know about the Provost Marshal, go to or the clerk. You need to spend some time in a law library and go and read an American jurisprudence. That's how you get your foundational understanding of law. Go read those legal encyclopedias. You'll be amazed at what you find out.
Okay. Because I think you said it was law redemption in court or something.
Law redemption in court. It's called law redemption. Well, on the internet, you can Google it. It's under the title "Dealing with Presentments." Dealing with presentments. Okay. You can Google that on the internet, and it will pop up. There is a PDF on the internet. Dealing with presentments.
Okay. Okay. Very good. Well, thank you so much, Yusuf.
You're welcome.
All righty. Bye-bye.
All right. Interesting call. Let me get Brother Dawu in Arkansas up next. What's up, my brother? Welcome to the show.
Peace.
What's going on?
What's going on, Yusuf?
Man, chilling.
Yeah. Trying to keep my head above water. I was listening at you today about the discharging of the debt.
Right.
And how you said they pretty much work hand in hand.
Right.
I got my little brother here. He just went to court today on a little traffic violation.
Right.
And he told the judge that he wanted the charges to be dismissed, and the judge told him set him a court date for a trial. And we was trying to see if is there any way that he could get the resolved.
Oh yeah. Well, you need to start corresponding. Remember, agree with your adversary before you get to court. The judge is not your adversary. All right, it is the solicitor or whoever it is that is in there that's representing the state. All right, and it's a debt collection. So you want it now. You just go in there and say, I want the charges dismissed. I mean, based off what? I mean, that sounds like a contempt type issue. I'm going to dismiss it for what? For what? Why did you tell him? You just go in and say, I'm going to dismiss it? Just dismiss this bullshit. Y'all know this some bullshit.
He filed some paperwork on some case laws.
Some case laws, okay. All right, now when we talk about case law, all right, case law is something that is going to be adjudicated in court. Now, is the case law, was it applicable to that particular jurisdiction, or was it just dictum? In other words, and we have to talk about this. The average person out there, they pull case law from all over the country, and they think it applies to a particular jurisdiction. There has to be case law there. That case law needs to be shepherdized to make sure it's still good law. All right.
Right.
And it has to be germane to the particular proceeding. I would not use case law unless I read the case. So if because you may be using it out of context, you won't know in what context that particular case. And judges will ask you that sometimes. Did you read this case?
Right.
Because I've read case law, and then I go read the case, and what I thought was being said by just that particular citation of authority was not what is being said in the context of the overall case when you read the case. You have to read the case and find out in what context that was being used. Very important.
Right.
But go ahead.
Well,
I wouldn't have used any case law, though. I mean, you didn't need to use any case law. I mean, you should have just went in and just tried to. I mean, what I would have did is say, look, I'm going to pay with a promissory note. You go that route. Why are you going to argue with them?
What's the promissory note?
A negotiable instrument. When you put in case citations, you arguing.
Right.
You going in there arguing. You say, I'm going to argue. And you're getting them jurisdiction. That's why he gave you a trial. But go ahead.
Right.
The trial is for arguing. Trial is for arguing.
Right.
Yeah.
Yeah, we don't supposed to do that.
Right.
If you operating as a private, on the private side.
Right. Because you go in there, if anytime they give you a bench trial or jury trial, you have just been a judge as traversing by way of argument. You're making an argument.
Right, and we don't want to do that.
No. Private people handle their matters privately. Private people handle their matters privately. They don't need any public intervention in, in getting a remedy for their particular matters. You're gonna do it privately. Everything is done privately. Public and private do not mix. They don't ever mix them. Don't you ever mix them. Now the problem is most of you are not considered or being presumed to be public because you're U.S. citizens. So there's an operational presumption that's already in place that you are not private. So we got to think about that too. They do have a right to kind of presume that you're in the public because most of y'all done been in the public all your life. You went to public school. You done been and most of y'all trying to get into public, be rappers and play sports and all kind of stuff. The average person out there I'm in the public right now. I'm on public radio. I'm forsaking my privacy to come out into the public and help y'all. So so that's you know what I'm saying. So you got to look at these things. You got to weigh it in and put it in its proper perspective. You know what I'm saying? Do you really understand what it means to be private in all of its aspects? Because you got to be all right, or you're not right at all. You have to be all right, or you're not right at all.
So he's wanting to know what type of instrument, the promissory note.
Well, you can use a promissory note, a very easy one to draft. You can look at my Creating Negotiable Instruments webinar. I've done several free negotiable instrument webinars, several of them. Get on my email list. I'll do another free one this week. I'll do another free one. Y'all have to go to radiohighfrequency.com. I might do one tonight. It just depends on what my schedule look like. But you need to be on the email list so y'all get the email list. It's first come, first serve.
I think I should be on your list. I should be on there.
Yeah, it's first come, first serve. And when I send out the email list, it's only 100 spots, and those spots usually fill up in the first 5 minutes. I'm just keeping it real.
Right. Okay. I need to get with you on the consultation anyways. I'm going to do that probably in another week or so.
Okay, that's fine. And also, it wouldn't hurt for you to use Google Images. And you can use Google Images and put in promissory note, and you'll see a lot of different promissory notes there too. But there are many different negotiable instruments. Primarily, you should read United Nations Conference on International Trade Law and Bills of Exchange and Promissory Notes, Articles 1 through 7, and study UCC Article 3. Those are your two primary things that you want to read and studying about negotiable instruments.
Hey, Liz, I got one more question for you.
Yeah, go ahead.
Okay, I got a piece of property, right?
Right.
And the property was it hasn't been probated because of other reasons, but I end up taking on the responsibility of the property. Now It seems like it's going to be a little confrontation about it. But the property the name that the property is in, the man is deceased.
Right.
And the woman that was married to the man, she never went in and had it put into her name. Okay. Even though she was married to but she ended up doing a quick claim deed over to me. But now she act like she want to start playing games with the somehow or another she just start the people are not honoring the fact that I have a quick claim deed to the property. So
let me ask you a question. What state are we talking about? What state are we talking about? Arkansas. Hold on. Okay, I'm trying to find out if it's marital property laws in Arkansas. No, Arkansas. Arkansas is a equitable distribution state. It's not a community property state. Equitable distribution state. Let me see. That though, if they were married, I'd have to look on that. I don't want to give you any wrong information. But if she quitclaimed it, the only way that she can challenge the quitclaim deed is whether or not she had the authority to deed the property over. Is her name or was her name on the original deed? I know they were married. Was his name on the original deed or her name?
No, just his name.
You're gonna need to research the equitable distribution laws in that particular state and see, because in a lot of under common law she would have the authority to do it, but under a legal regime I'm not quite sure, so I don't want to give you the wrong information. But her being married to him, she does have certain rights to the property, but I don't know if that right extends to her having the ability to convey that property to you by quitclaim deed.
Okay, now this is my question. I've invested a nice chunk of change in this. Is there any way I could protect the interest that I put into the property?
Well, yeah, you can file a lien against the property. You file a mechanics lien. Have you done work on the property?
Yeah, and I got all my receipts and everything.
You need to file a lien. You need to go file a lien on that property then, a mechanics lien against that property.
Now, how would I? What type of paperwork do I need to do that with, Yusef?
There is I can't tell you straight off the top of my head, but there is a procedure probably in your particular state for filing a mechanics lien, and which is probably statutory. You need to get with me on a consultation, and I'll go through that with you on that. But I do know that you need to file a lien on that property for all the work you've done on it, regardless of whose name is on the title.
And not only that, I've also been paying because I've also been paying the mortgage on it as well.
All that goes into your lien because it's all interest you have in the property.
Right. Well, listen, like I said, in about another week or so, I'll link up with you again for the consultation, and we'll go from there because I really want to get from under this property, period.
Right, I understand. Trust me. So, especially when somebody starts flipping. I got a friend who's in jail on somebody, and they kind of had a little situation like that, man, where the lady came back and said he tried to steal the property and all this kind of stuff right here. So, just make sure you do. Let me tell you something, man. The spoken word. Now, one thing you do have, though, that's in your favor is you have a deed. So they can't say that you didn't act in good faith or did something underhanded. The only thing that could be challenged whether or not the efficacy of that deed or whether or not, it was in fact lawfully conveyed over to you, and whether or not she had the authority to do that. That's the only thing that could be brought into question. But I know what you mean. I like to get out of situations like that too. I don't like to be messing with people who get amnesia and because they see you done figured out some kind of way because you got some knowledge to do something. They feel like you done took advantage of them in some kind of way due to their ignorance, and so it's not really a good situation.
Yeah. Yeah, you don't remember talking to me, do you?
You sound familiar.
I already know I asked you to talk to millions of people, but I was the brother that was in the halfway house a couple months ago.
Oh, I remember you. I do remember you. You called me from the halfway. Oh, hey, hold on. Let me make a quick announcement. Hey, y'all, we're gonna go overtime. I'm gonna go overtime. You got about 45 seconds. If you are in the chat room, you need to call in. The number to call in is 424-222-5250. You got about 30 seconds to call in before this recording ends. If you're not going to continue listening, this recording will be on in our archives. So you can go to blogtalkradio.com/high frequency and catch this show and all of our past shows. It will be in the recording, but you need to get in right now. Also, make sure you get your U-Box. Go to radiohighfrequency.com. Go on our website. Pick up our webinars, pick up our U-Box, pick up everything because we're rolling this stuff out, all right? So go ahead. All right, go ahead, brother.
I
remember you.
Yeah. So I still been studying. I still been listening to the websites, and I'm working on the do not detain list, too. I'm working on that.
Make sure you get on that. That's important. That's very important. Make sure you correspond with your public officials and let them know your position as it relates to your rights. Make sure they understand.
Yes, sir. Yes, sir. So, like I said, about another week, I'll be getting in touch with you so we can go over this real estate thing.
Okay, brother, that's fine. I look forward to hearing from you. Email me at highfrequencyblogtalk@gmail.com, Brian. I look forward to hearing from you, okay?
All right, Yusef.
All right. Peace.
Peace.
All right. Peace. Let me go back to the phone lines real quick. Let me get Sister Tanisha in Michigan.
Hi, can you hear me?
Yes, I can hear you, sister. How you doing?
I'm great. How are you?
I'm doing fine.
I have just a couple of questions. My first question is, how can I obtain my master CUSIP number, the CUSIP number associated with my birth certificate?
Oh, that's very difficult to do. You're probably going to have to get with somebody, some type of correspondent with the department, with the DTC, Depository Trust Corporation, the Depository Trust Company, and find out who is the agent is, and give him your information, give him your Social Security information number, and see if he can find a CUSIP number related to that Social Security number. There are many different ways of doing it. There was this one group, they claimed to do it. They call themselves CUSIP numbers at hushmail.org. They claim to do it, but I don't know the efficacy of it. I haven't pursued it to that degree. But there is a CUSIP number associated with your birth certificate. I haven't had time to really explore it to its highest level, but you know, this is what they say. You can get this CUSIP number. You can get it once you have a CUSIP number, because they trade. Let me tell you why I know they're trading it, because that is a trust. They put in everything in trust. It's an irrevocable trust, and the duty is like a certificate. And there is a duty of these trustees to make money for the trust. That's why they trade in all this stuff on the Depository Trust Clearing Corporation, Deposit DTC, and all that, because they're required to. They're required to do that. That's a fiduciary duty of a trustee to do that, to make money for the trust.
Okay. And as far as like obtaining proof of it being traded, I would have to have that CUSIP number in order to do that.
You have to be very diligent in seeking. I mean, it depends on what you need it for. Like, I haven't really seen a need to have that information, me personally. But if you are involved in something that you find a need to have that information, I mean, you could pursue getting the original birth certificate. Go to your and this is going to take an effort for you to do, because they ain't going to give you this information easy. They're not just going to roll over and give you this information. So this is the kind of information, once you start trying to acquire it, you got to be very diligent and be willing to go the extra mile to get that particular information. Like, I was told that if you ever get your hands on your original birth certificate, you're going to find that it's been traded all over the world. It's going to have a whole bunch of signatures on the back of it where it's been traded.
Wow.
So,
okay.
It's obvious that it is a negotiable instrument, because at the bottom of the birth certificate you have American Banknote Company. And American Banknote Company only creates stock certificates and bonds. That's what they make. Stock certificates and bonds. So why is your birth certificate being printed by a company that only makes stock certificates and bonds? And we all know that a stock certificate is the same thing as a trust certificate. That's what a birth certificate is. In my opinion, it's like a trust certificate. It evidences your beneficial ownership in the trust and your prorated share of that particular trust, which is what they give you when they give you Social Security. They give you Social Security, they're giving you benefits, but they're only giving you like small amount of it. They're just giving you just enough to survive. That's all they're required to do as fiduciaries, as fiduciary trustees. But anyway, I'm sorry, sister. Go ahead.
Oh, that's okay. It's interesting. Okay. My second question is with regards to getting someone out of prison. I have an uncle, and I'm trying to help him get out of prison. He was sentenced to natural life, and I looked up his file. He had 3 counts that they had him on, 3 counts, and 2 of the 3 have already been, I guess, satisfied from the time that he's already done behind bars. The third is the one that hasn't been released yet, or, you know, I guess that's the one that's going to keep him in there for the rest of his life.
What'd he do?
It was murder, I believe. It was
Okay,
one was murder.
Now, let me ask you a question. The reason I asked that, now, murder You're not finna use no commercial remedy and get somebody out for murder.
Okay. Not possible, huh?
You know what? Let me say something. I'm gonna give you my take. This is my opinion on that.
Okay.
When you murdered somebody in the Old Testament, they took your life. They still do that to a degree today, but when they give you life in prison, that's called civil death. You're dead. You know, there's a life that's been taken. So it's like, I don't know if he did it or not. You know, it's not me. I'm not here to judge him or what happened. It might have even been in self-defense for all I know. I don't know what happened. I don't know the facts surrounding the case. But what you have to understand is when you injure someone, you take someone's life, you didn't give life. You can't take it. When you rape someone, you know, rape, the reason they took your life for rape is because the virginity of a woman is a very serious matter. And most of our women don't even understand it. They have absolutely no clue as to the power of the feminine energy and the responsibility they have in making sure that they're not contaminated by the wrong type of masculine energy. All right? So and it was so serious in a time where people knew all these sciences, that's why they would take your life. So you got to understand that the laws of God are not out of place. It is people, it is heathens who are out here because they're pumping this doctrine called grace to the Christians. Grace is for heathens. Grace is for savages. Grace is not for God. It's not for people who take responsibility to adhere to the laws of the creator of the boundless universe. And there is no way possible for you to circumvent law. And Jesus made that very clear in the Bible. Y'all trying to twist that shit so you can go out there and do what the fuck you want to do and ask for forgiveness and have in your mind like you still going to go to heaven. And it's not directed to you, sister. It's directed to the audience.
Right.
But, like I said, it's like with murder, you're looking at, you're going to be hard-pressed. The only thing that I would suggest, because here's the thing. If you are innocent, you won't resign yourself to, a lot of dudes are in jail because they've resigned to the fact that they belong there. They were guilty and they think that they belong here. You know, I had a friend who had life in prison. He had natural life in prison. He was in California. He got life. It took him 15 years, but he got out. He did 15 years in prison. But when I met him, he had already been in about 10, but he got out. And here's the question I asked him. I said, say, man, how did you feel when them people gave you life in prison? He said, I could never imagine in my mind doing the rest of my life in prison. He took me into the law library, and in the law library, he showed me a group of books, and on the books on the binder, there was a picture of a key. And these are law books. And he told me, he said, these are the keys that are going to get you out of here. You ain't going to get your uncle. Is this your uncle we talking about?
Yeah.
You're not going to get him out. He's going to get himself out. And he has to make a decision that he wants to get out. All you can do is provide him with information to spark something in his mind to make him want to be free again. Because anything you can conceive and believe, you can achieve. Believe is that element. Trust me, I've been in the pits of hell. He can get himself out of there, but he gotta have a resolve that is unwavering if that's what he wants to do. That's what it's going to require.
Okay. All righty. All right.
And I'm
well,
sorry
that's all
about
the questions I have. I thank you so much. Oh, that's all right.
Thank you.
Thank you so much for your information.
You're welcome, sister.
Peace.
Appreciate it. Peace. Okay, y'all. That was my program director. He was telling me I got to get my ass off the air. So I have meetings to attend and business to attend to. But I got time for one more call. I'm going to get Brother Heru in Brooklyn. He has a call. He has a question. Brother Heru in Brooklyn, New York. You're on the air, bro. What's happening?
Brother Yusef. How are you, my brother?
I'm doing great, bro. What's going on?
Hello.
How you doing?
I'm doing well. I have a quick question. Well, I have a few questions, but I'm going to limit it to one.
All right.
Birth certificate authentication for a green card holding non-citizen.
Well, I mean,
what would be the process to do that?
I mean, you need to go to your particular country and find out what does it need. You know what? I mean, let me put it like this. I bet the State Department would authenticate it because let me give this to you. Let me do it like this. I'm gonna go to the State Department website. I'm gonna read their shit to you, okay? And they tell you. Because I don't see what are you going to go to Office of Authentications on the State Department website. And here's something real interesting when you read it. You're going to go down and it's going to give you authentication certificate requirements, and then you're going to click on General, and they have birth certificates, marriage certificates, death certificates. Then you got general documents. You got affidavits, agreements, articles of incorporation, bylaws, commercial invoice. Now, notice here that they do authenticate affidavits. And then now, they give you the directions on the authentication of an affidavit. Here are the requirements. General requirements include acknowledgement by a notary public and certified by the clerk of court from the county in which the notary is commissioned, and certified by the Secretary of State from the state in which the document was executed. So if you were born in another country, you need to have that certified by the Secretary of State or whoever that same officer would be in that corresponding country. Have them authenticate that for you, and then you get it, and then you send it to the State Department and have it authenticated. They tell you right here what they will do and what they will not do. Because all states are considered countries. I mean, I'm in California. California is a country. It's a country. There's another name for a country is state.
So I'm wondering if that could be done at the embassy.
Maybe. The consulate is responsible for the commercial affairs of all of the people from their corresponding countries. If I was going to start with somebody, I would start with the consulate, the office of the consulate, and find out.
Okay. Very good.
Does that answer your question?
Yes.
Okay. All right.
I have the birth certificate from my country. I mailed away for it. Got it a short while ago. So I'm going to take it into the consulate and have a conversation with them and see what they say.
Yeah, find out what they say. You know, I know the consulate is, I know they should be able to direct you. You should be able to find out everything you know about going to that consulate. But call back in and let me know what happened, brother. Share it with the family when you find out, okay?
I will. Thank you.
You're welcome. All right, y'all, look here. I got to get out. I'm sorry. I will be back. I know y'all missed me. I wasn't on last week. I was handling business, y'all. But I'm back. I'll be on tomorrow on the Natural Law Hour. Thinking about doing the Natural Law Hour at nighttime. But I will be at. Make sure you get on our mailing list. Go to radiohighfrequency.com. Make sure you get on the mailing list, all right? I want to thank everybody. Thank all my listeners for making High Frequency Radio into the radio network what it is today. We got a lot of things coming in the very near future to improve on what we're doing. And I'm going to continue working hard to bring you the information you need to do to help you with your situation. Peace to all the gods and goddesses, and I'll see you tomorrow. Peace.
You're listening to Yusef L on the baddest radio network on the planet, High Frequency Radio. You're listening to High Frequency Radio Network. Connect with us at RadioHighFrequency.com.